Comms, no, we're going online.
So you're going live on Facebook and Zoom is both?
Yeah, we're going live to YouTube and then comms is gonna post it to Facebook.
So we're not going to be live on Facebook?
No, we will, because they're gonna post the link to the YouTube video on Facebook that'll have the live stream on the. So we're going online.
Okay, so look at your on as live on Facebook and includes both.
Yeah, we're going live.
Who wants to watch tonight's show,
If it's on Facebook, they will be able to watch it.
so they can go to Facebook.
I'm hearing my voice come out and speak. Okay, yeah, what's
All
going on?
right, so let me ask my question first and then you can answer, so I can two confused.
Okay.
So if I was sitting home and I wanted to watch this and I normally watch it on Facebook, I would go to Facebook, I type in C. Yeah, CNBNY, and if I would, be able to see, say, CNB is live right now.
That's not what this meeting, look like there'll be a live video playing on Facebook.
Okay.
But like, it's just, it's like a thing, because if they want to post it on YouTube,
Yeah, yes, which is fine,
they just coordinate this.
because there's been, some concerns by, others, citizens who seem confused by it, and I wanted to clarify it. So I thought that's exactly what it was that they did.
That's what it's about, we've had it speak.
So,
Snap notes on the side.
so we are live now?
Yes.
No, I put on Facebook though,
I just, yeah, I think that we're immediately. I told them we're going live now.
let me check
How do
the,
you fix that? In
Uh,
the future, that's not right now.
let me check, let me check the YouTube page to see if they're on there too.
Turn down the.
Yeah, yeah, we can go now for comment on. We have like this thing called, and I'm not.
Is that just a video, is that just to
It's like, it's
let people know that they're on recording or actual ones?
transcript, like it produces the transcript based on the report.
It doesn't make a meeting note, like a summary?
No, it does, but like, it's making like, everything I'm saying right now will be in the transcript.
Okay, so I'm going to remind everyone, since we are recording, that we all have mics in front of us, and you got to hit that button in front of you so that not only will it amplify in the room, but it'll be picked up by Facebook and Zoom. What's that? Yeah, you have to turn the mic on. Everybody knows how to turn their mics on, right? All right. Okay, so while we're looking into why we're not on Facebook yet, this is just a work session and there's no comment from the public, but it is just an opportunity for us to ask questions and clarify anything we might need clarified prior to having the formal public hearing. So with that said, I don't, no, I'm not sure it has to be done as part of the public meeting. So Lucas, you could answer that. So the findings of fact that we are trying to finalize and for me to approve and sign, do we need to do that at the public hearing or can we talk about it at the work session? And then, right, there's no, okay. Okay. All right. So relative to that particular issue, let me get my, there are 3 or 4. How many are there? There are 4 findings of fact that we're a little behind on. There's 28-30 Millington Street, 154 Stevens Avenue, 420 North Terrace Avenue, and 35 South 8th Avenue. So I will just ask everyone if they had a chance to go through them, if there were any questions or concerns about the way they were written, and if they're on point. Everybody's good, pretty much?
I only had a question about Millington because
Okay.
wasn't that like a revival of? No, that was South Eighth Avenue. It was a revival of their variance.
Yeah, so that was,
Extension, it was like,
it was an
it
extension,
was an extension.
correct.
So I didn't see the extension language emphasized. It was almost like it was a whole new variance request.
I did notice that it said it was an extension. Maybe Lucas, you could help us since you wrote that. Where it clearly states that this was
Next
primarily an extension.
On South Eighth Avenue,
Well, I thought it was Millington or,
South Eighth.
okay. You threw me a curve.
I didn't write it.
That's right.
So if you said it, the question was about.
Whether it's an extension?
Was it? Like, they had the variance approved and then they came back for an extension. Not sort of, not the request.
No,
for
I thought
variance.
Millington was the extension.
Okay,
I don't
so-
think South Eighth was an extension.
Building that. You can say that again?
Yeah, but
No,
it's
it's
already.
not on
built.
the agenda. So there are four findings of fact.
Oh, they already fell apart, so they ready for like legalization.
Of what they already built. Yeah.
I gave them a.
I have them all.
Email.
Already know.
Okay, so we clear on that? No. All right, so I reviewed them all, and since I'm the one who ultimately has to put my signature on them, like I explained earlier, and I'll explain it to the public as well, in the past, the findings of fact were sent to me after the meeting. I reviewed them. I raised any concerns to staff. There was a correction done if it was required, and then I signed them. I just think, especially with the fact that we have a delay in a lot of these findings, but even moving forward, if they're timely, and hopefully they will be timely moving forward, that it would make sense for all the members of our board to see these findings and review them briefly. And then if it's, more sets of eyes on a document that's going into, that will be used for moving forward. And we just want to make sure that there are no mistakes, and it would be better if everybody looks at it. So that's what we'll do moving forward. And that's the reason why we're going to do that moving forward. So,
I have a question.
yeah.
So just for the sake of governance and how we should do this, should we, is there a vote that we need to take with respect to the finding of fact? Should we go through each one and just say we're good, or just the omnibus?
Yes. So no, it's not necessary.
Okay,
It's past the public hearing.
Okay.
It's just a matter of making sure that what was written, what we discovered and what we concluded is written properly.
Is
So it's
reflected.
really, it doesn't have to be done in public. It just is being done because of time, and it's the ability for us all to be together and for me to be here and sign them when this meeting's over. But no, there's no need for that. If you wanted to bring it up, if you had a concern, it would be to send an email when you get it from staff to say, and then we could all look at your concern and decide whether, oh yeah, good catch, and make the change and go from there.
but if there are no changes, then we're fine.
Right. So right now, I don't see the need for any changes on the four that were submitted to me. And unless everybody, if anybody has anything different, let me know. If not, then I'll be signing them at the end of the meeting.
So when will we be getting the findings of fact? Like in between meetings, just ahead of the meeting? It gets to be a lot to read at the last minute, so. How can
That's
we
correct.
start?
So I don't, this is out of the ordinary situation. Once we get caught up, as you can see, we don't, I mean, I don't know, how many times do we get to the point where we make, how many applications do we decide a year? A dozen maybe, if that? Probably less. So they're not going to be that many.
Okay,
We'll have time if there's no need for you to say, for you to review them. So in other words, if you get them 5 days before our meeting, they don't have to be approved by our meeting. There's no time frame there. It's just take a look at them within a reasonable time, a week or so. Give yourself time to review it and then send notes. And maybe Maria, when they go out, say, please respond within 10 days or something like that. And, hearing nothing, we're assuming you don't have any issues. All right? Okay, that was. You put your mic on.
Okay, just to be clear, and Lucas and Maria can probably speak to this. My understanding is that we are mandated to issue the findings and conclusions within 60 days of the vote by the board. So 60.
60.
Right, so to the extent that we typically will have a work session every month or on the day, on the scheduled meeting day, then it would make sense for us to issue the draft findings and conclusions 30 days from the board's decision or the board's vote, which would give more than enough opportunity for each commissioner to review the findings, review the conclusions, make their comments or recommendation for edits at the next work session. We can then finalize it in our work session, and assuming that it comports with everyone's understanding at that point, then we can just put it in final form and have it signed, if that makes sense.
Yeah, so I just did speak to that, and I don't want to, what happens is we tend to get a lot of information 5 or 6 days before our meeting, and it's a lot to review. And so Wendy's concern was, are we going to have more last minute things that we have to look at and review? So the fact that it does not have to be finally approved, the 60 days, I agree with you, within 30 days, and you're the one who's going to be tasked with getting us those findings, draft findings within the 30 days. And if you can accomplish that, then we will clearly be within the 60 days, even if it's not discussed at the work session. So if somebody finds a problem and sends an email, it should be a fairly straightforward, since we don't have to do it in public, it would be a straightforward email back and forth to say, oh yeah, you're right, or oh no, this is the way I saw it. If it becomes an issue, and then we have to have a special meeting because of it, but I've never seen that to be the case, so.
That's fine.
All right. Okay. So does anybody else have any questions on the agenda today? Board members?
Question about, payment in lieu of parking spaces for one space. What is that? Is there a rule? Is there an amount?
So, you know what, put this mic closer because I'm having trouble hearing you.
Do we have the schedule now for payment in lieu of parking?
Yes, so we had that,
Back,
when,
yeah,
recall?
are we thinking it pertains to tonight?
So relative to, the-
Terrace Avenue.
so yeah, any application that we
Is
see where
lacking.
parking is a parking variances are requested, we will apply that rule,
Right.
as a fee in lieu of on-site parking.
Right, okay. I don't remember the threshold, like when it's.
No, I don't either. So you know what, that's a good point, Maria and Lucas. And Will, who's ever putting together the agendas, where we have the variance chart. You might want to put in there the fee, now assuming that variance is granted, but at least we'll have a basis and the applicant will have a basis for what the dollars will be. Okay. All right. And So I know there was, well, we can wait till the applicant's up, but there was one thing that Mr. Scully, you were asked to opine on the South Terrace project and the distances to church and playground, and the fact that the applicant is talking about state regulations in the cannabis law as opposed to Mount Vernon's regulations, which vary. And were you able to make any determinations?
Not yet. And I will.
Okay, so you're having trouble hearing?
I mean, I heard what he said, but yeah,
Oh,
it was a little, I think if Mr. Scully
So I don't
could
think your
move
mic is
your
on.
mic up or close. There it is, there.
It's on now.
I'm gonna suggest.
Okay.
Yeah, because I want to make sure everybody can.
Yeah, that's an issue that our legal counsel should confirm, correct?
Well, yeah,
that-
we do need our legal counsel to confirm that and
To
so,
confirm the hierarchy
right.
of the.
And so, which, you know, for the public and everybody, Carl Scully is now the land use internal, which is not internal, who's contracted to do land use boards. So he took that position over January 1 or so. So he will be the one we ask those kinds of questions, and we'll do that research. So where does that put us though, relative not having that decision? It's going to be tough to make a decision on this application, I guess.
Yeah. I mean, we'd need that confirmed.
Okay.
You know, our council is going to review with New York State and I guess the Cannabis Review Board, the hierarchy of law pertaining to that issue, to that application.
Spoke at length with the Office of Cannabis Management. I mean, they told me that the licensing is separate from the zoning application. They've already been granted another license, stopping for 2 more years.
Yeah, it's not about the licenses, the distance between the house of worship,
Oh.
those laws, the New York State law
Yeah.
versus the local ordinances.
That's right.
So it seems like our new council should give us an opinion
Okay.
about that.
Yeah,
And
okay.
we'd need that in order to make a ruling
Very good.
today.
Okay. It's the wrong. You know, maybe we could talk briefly about the schedule for next year.
Oh, yeah.
And
That's fine.
Lucas, I know you and I had a conversation briefly about what happened? All right, sorry.
Oh, yes,
We had a brief conversation about the February date, correct?
that's right.
And so that there could be a problem with staffing, and there's another holiday, school holiday that kind of is in the middle of all that.
Right.
And so we were discussing whether we should make a change to that date.
Right, I mean, basically, I have it on a calendar here. But, you see, this is the date that you're scheduled normally,
Mhm.
the 3rd Tuesday of the month. However, it's a government holiday the Thursday before and the Monday prior. So staff doesn't have a lot of time to kind of, because we're like not allowed in the building.
Right.
Also, the date that you have, if you go by the 3rd Tuesday of the month, that's also Lunar New Year, which is a major holiday for certain populations.
Mm-hmm.
Schools are closed. You know what I mean? It's just, it's a
Okay.
date to avoid if you want to avoid. So there's a lot of reasons to change it, but it's up to you to what you want to do.
Yeah, no, so, based on our conversation and that information, I thought it would make sense for us to look to see if we could change it. So the question is to the remaining board members and actually staff, so you're recommending moving it to the 10th?
Yes, because if you move it forward, it's adjacent to the ARB meeting, which is another issue.
Right.
Then we're like,
Yeah,
you don't have a full attention because we're like.
yeah,
Yeah.
right, yeah.
So we would recommend, because moving it to the 10th. Now, the thing is, there's no new applications, this would normally cause an issue if application was submitted new, because it would shorten the amount of time required for the noticing. However, as of.
Excuse me 1 second. I'm just going to ask, ladies and gentlemen, I'm sorry, excuse me. If you're going to have a conversation, could you go out in the hallway? Because it really is pretty loud in here when you do that, so. And I'm trying to pay attention. I apologize. I used to be able to listen to 2 things at once. I can't do that anymore. So. Thank you. So let me ask the rest of the remaining board members or all other board members. Is February the 10th a reasonable date for us to make a change to our February 17th meeting? Does anybody have any problem with that date? It's the second Tuesday, correct?
I'm sorry, Mr. Chair, I don't have an issue with that.
Okay,
It works for me.
works for you?
Works for
Adele?
me.
All right, works for me. There you have it. That was easy. All right, so do we need to, we don't need to rewrite this. We can vote on this tonight with the 10th and then.
Yeah.
Yeah, then ultimately what you put on the record will be that February 10th date, right?
Right, and just for awareness, it's not gonna impact noticing requirements for that meeting because there are no new applications for that
Okay.
meeting. Unless something gets submitted in the next couple of hours, we don't have any new applications. It's just all returning applications. So the
Okay.
noticing requirements should be fine for that.
All right. All right. So we got 4 more minutes of the work session. Is there anything else we can get out of the way or that there are questions on? That's a doozy. All right. We have anybody online, Will? So are the cameras working properly when you guys speak? Are they going on?
Yeah.
All
Yeah,
right,
they're
good.
pretty good.
Okay. It is.
It's 6:30.
Okay. It is 6:30. Okay, welcome everyone. Tonight's meeting of the ZBA begins at 6:30. We're streaming live on Facebook. Although before I say that, are we? Did we get that cleared up? Yeah, okay. And it's available on Zoom when the Zoom link was transmitted or is on the website. So item 1, roll call. Maria?
Please respond when I say your name. Commissioner Ball Adipo,
Here,
Commissioner Castillo,
Present,
Commissioner Pinnock,
Present.
Chair Justino.
Here.
Okay, we do have a quorum.
Okay. And then item number 2 is approval of minutes. Unfortunately, they're not available, so we'll carry those over to next month. And item number 3, public hearings, and this is a continued public hearing. 3.1 case number ZB 25-4, 219 West Third Street, section 165-62, block 1117, lot 8 in the CB Commercial Business Zone. The board previously received proof of mailing, proof of publication in the Journal News, and proof of initial sign posting of the application. We also received an affidavit of sign posting. Board received photographs showing the sign posting, and providing notice of today's meeting. The owner, Michael Giori of 230 West Third Storage LLC, is represented by his architect, Tom Abalama. The applicant is seeking to obtain area variances for a proposed self-storage facility at 219 West Third Street. The subject property is 21,074 square feet, is located on West Third Street near the intersection of West Third Street and South 14th Avenue in CB Commercial Business Zoning District. Area variances requested according to Chapter 267, Attachments 2 and 3. Building height in stories, permitted 2 stories, proposed 5 stories. That's 3 stories, 150% variance, and the footage 67.5 is 125% variance. Building coverage as a percentage is 50% permitted, requesting 86%. It's a 72% variance. Impervious surface coverage, 80% permitted, 96.5% proposed, 20.6% variance. Parking spaces, 22 spaces are required, 16 spaces are proposed, 6 space variance of 27%. Loading zone spaces, 4 spaces required, 2 proposed, 2 space variance requested, 50%. The application has been sent to the Fire Department, Police Department, Water Bureau, DPW, and City Engineer for comments. Secret, the proposed use and variance and area variances are classified as an unlisted action in secret purposes. The ZBA should determine whether it intends to serve as lead agency for the environmental review of this action. So I just have one quick question before we go forward. This, they will be before the planning board, is that correct? And the ZB and the architecture review, is that? Can somebody verify that for me?
Yes, this application will go before, after this
Okay.
board, planning board, ARB, and also city council for the curb cut.
Okay, all right, I see that now. So well, we can wait. Why don't we hear the applicant?
Good evening, ladies and gentlemen. Jack Adesso.
Good evening.
I'm the attorney for the applicant, 150, and my office is at 153 Stevens Avenue, Mount Vernon, New York. Seated with me is the project architects who are here to respond to our request for the variances that we need. So if I can begin.
Yes, please.
Okay. This project started in 2021. It went before the city council because we had no zone in the city that allowed self-storage specifically. So we had to go to the council to get what was really kind of a use variance, but a special permit. Council granted it. And what they approved basically was a building with 5 stories. They approved parking for 16 spaces, okay? And everything else was conforming, with the exception of the building height, which was 67.5 feet as opposed to 56.5 feet, okay, which was approved by the council. The building length remained 153 feet, so that didn't change. The lot coverage, they approved 70%. We're asking for 96%. The lot coverage of impervious surface was 96% approved. And basically, we're just under 96 or just over 96%. I think we're 96.6 and it should be 96.5. And so far as the parking, as I said before, they approved 16 spaces, even though 20 some odd spaces were required. Council approved 16 spaces, and we provide 16 spaces. So we're basically here for area variances for the building height, the lot coverage, the impervious surface lot coverage, and a change in the original plan, which had offices on the ground floor and retail space. We are now proposing warehouse space and a small office for the building. So that's a change to the first floor. It wasn't what was approved by the city council because it wasn't part of the presentation. But in redeveloping the building for this proposal that we have tonight, the applicant and the architect converted the retail office space in the first floor to storage. So that's really the nature of the application. We're dealing with 3 or 4 area variances that are the minimal variances we need to make the project work. And like I said before, it has already been vetted by the city council, public hearing, use variance, special permit, and with the approved items that were approved by the council. So that's what we're here for.
Okay, so I'm not quite sure I agree with what you're saying based on the fact that the city council created a zone specifically at the behest of this property owner and proposal. And that zone, well, first off, you're not looking for that zone at this point. So,
No, we are looking for that zone. Wait, no, that's not an
Well,
accurate statement.
all right, so hold on a second again. So because I really didn't finish. And so part of it was you were able to get a bonus floor if you put retail on the bottom. And that's been part, you guys were here before, and that's been part of this. The whole thing has been very confusing, is what is it that you're looking for? You're now portraying that you're looking for what you went to the council for. And in reality, that is not what you're presenting to us. And Jack, you can shake your head as much as you want, but that is not what is in front of us. If you are basically saying that all these area variances that are on this list that the building department came up with are incorrect, because you're no longer using that overlay. You want to build a building different from what that overlay calls out, and you're now in the CB zone, and so therefore your variance requests are based on what is currently allowed in the CB zone. So that's why those variances are here, different from what you're saying, the variances that you're looking for.
So if I may be so bold, Mr. Chairman, what do you perceive the variances are that we're requesting?
What I see on this document, from what I can tell, unless,
Basically, they're the same things that we asked for. The only difference was,
you said you could build 5.
well, let me finish what I'm saying.
Okay, go ahead.
The only difference was the parking spaces. You said 22 spaces. The council approved 16. This application has 16 spaces. So there's no variance required there.
But you're not using the zoning as it was laid out in the overlay zone that was created by the council. You're building a building in a commercial business zone where the parking spaces of 22 would be required based on what you've submitted, not 16. If you want no variances, then build it as the council has agreed to let you build it, with the retail on the bottom, and then go before the planning board and go from there. You're coming to us because what you've presented is not the overlay. I'm
You
not,
know, I'm a little dumbfounded by this.
okay.
Because as far as I'm concerned, any zone, whether it's an overlay or not, you can request variances from what the zone requires, okay?
That's correct.
So why can't we request these variances now before the zoning board?
So Jack, you were involved in a project that was looking to use an overlay zone, and I won't get too specific.
Right.
And there were multiple,
There was no overlay zone at the time we presented this application. This zone was created as a result of this application.
correct, right,
Okay.
I acknowledge that.
So we're not looking for an overlay zone, or we're not looking
Okay.
to
I
comply
agree
with an
you. You're not
overlay
looking
zone.
for an overlay zone. You're looking for a building that looks like that, that's 5 stories high, that in the CB zone would require this list of variances. If we can't agree on what it is that you're looking for in variances, if you don't agree with what the building department has come up with and the planning department has told you are the variances and what is presented to us and what is on the agenda, and you're saying there's something else, then we're still miles apart in figuring out where we are in what we're looking at and how to approach it.
So you're saying that the plan examiner, in reviewing the plan, listed these variances that were needed.
That's my understanding of the process.
And you're telling me that the planning department agreed with that?
I was in the room when the letter was drafted.
That's not what I asked.
So, yeah, we agree. Planning agrees because I was sitting in the room when.
Okay, so what exactly is it that planning agreed to?
Okay, so let's go through the ABCs of area variance applications. Okay, so in this case, the applicant, Mr. Abalama, met with me and Deputy Commissioner Mamak at the building department. Mr. Abalama presented his plans, showed us the plans, and said, "This is what I want to build." Then the Deputy Commissioner Mamak reviewed the plans, and I was sitting there, and she says, "Okay, well, you need this doesn't conform with the zoning ordinance, and these are the variances you will need if you want to construct this building." So it's basically like a denial. She says, you cannot build this because the law says you can't. And these are the sections of code that say why you cannot build it. So Mr. Abalama is exercising his right to come before the Zoning Board of Appeals to appeal that decision. So the Deputy Commissioner identified 5 different variances, 5 different ways that the application does not conform with the zoning code. And Mr. Abalama is here, and you are here to appeal those decisions. So that's what we're doing.
Okay, so the issue is, what are the variances?
The variances are for building height. It's 5 stories where 2 stories are permitted, or 67.5 feet where 30 feet are permitted. So that's the first variance. The second variance is you're allowed building coverage of 50%. But the building shows 86%. So that's the other variance. The third variance is for impervious surface coverage. You're allowed 80%, but the plans show 96.5%. So that's a third variance. For parking, the ordinance requires 22 spaces. You're showing 16 spaces. So that's the fourth variance. And finally, for loading zones, 4 spaces are required according to zoning, and 2 spaces are provided. So that's the 5th variance. So if you can make arguments for using the 5-point test for why the benefit to the applicant outweighs the detriment to the city to grant these variances, then the board will deliberate and then choose whether or not to grant or deny the variances. That's why we're all here today.
Well, we have a fundamental difference of opinion as to what the council approved. Okay, for this specific project.
So this is a conversation that we could have at the staff level at City Hall during work hours instead of taking up the board's time. The board is here to review,
really? I don't
No,
intend
Mr.
to take.
Desso, excuse me. So the thing is this. What you went to the council for is not what is being presented here at the ZBA. So you're representing that you went to the council and they gave you approvals. But what you've come now to the ZBA with is not what you went to the council with, is not what the council approved. That's where the difference is. And you seem to be still saying that what we have on this agenda is incorrect. And so, and you have a right to disagree, but right now you have not given any reason why you're correct and we're wrong. So,
Could just give you a minute, Mr. Chairman?
sure.
Just let the council know, I'm Thomas Moran, the other partner. Mike McGurry is he's out of town today, but I'm the original owner of the property and the subsequent partner of the deal. So I've been in Mount Vernon for 20 years already, operating the prior business and converted a very decrepit building, run a successful business for 20 years, and I just wanted to convert it to this project. So nothing but respect for the city to make this work.
Yeah, and no disrespect to you or the
I'm not
applicant.
taking that.
We're not here to give anybody a hard time. We have our job as Lucas Herbert said, is to look at the facts and make decisions and balance the pros and cons for the city and the developer. And we're here to do that, except we have it's hard to even move forward because what has been presented by the lawyer is different than what we see. So until we're on that same page, I don't know how to move forward.
Okay. So you're saying that the ordinance, as it stands now, okay, allows three-story building?
That's correct.
Or
yeah.
I'm sorry, two-story building.
The zoning, the CB zoning
Right.
allows for 2 stories, correct?
Okay. So when we went to the council for the use variance and the application that was presented with the building and the parking, the coverage and all those issues, the council granted the use variance and approved the building height at 5 stories and the parking at 16 rather than 22.
So the council does not approve variances. What the council did, well,
Okay.
you're a lawyer,
No.
so let's be clear with each other, right? The council created zoning for this developer to put a building up that was self-storage where it wasn't zoned before in the city. So what they did is they did accommodate you and they laid out specifically what the envelope would look like and how many parking spaces you would need based on, I think it was 4 floors, give you a 5th floor if you put retail on the bottom. And I don't have all the details, but it is written in chapter, wait a second, let me put my glasses on. Section 267-32, special permit use, standards and requirements for special permit usage, self-storage. So right here, this really lays out what you could do. Now, again, if you came to the city with a project that fit into this zone as it was written, after the building department look at it, you wouldn't even have to come before us. You would just need to come before the planning board and the ARB and get those approvals and move forward. But you're
Understood.
not presenting that. You're not presenting anything within the way this particular zone was created. And so now you have what you have, and that's fine.
Client wants to proceed on the area variances as you lay them out. In other words, 2
Okay.
stories by code, we're asking for 5. Think you're wrong, but that's okay.
I didn't say anything.
Okay. So we're going forward with our request.
Okay,
As we've asked for the variances, we're asking for a height variance, 3 stories, 67 feet. You say 2 is permitted, we're asking for 5, so that's a variance of 3 stories.
Okay.
The lot coverage,
these variances.
Yeah, but this is only a memo. This isn't the law.
Those are the five that Lucas told you.
Right.
Mhm.
So the variances that the city say we're required to present to the board and request the variances. 3 stories, 37 feet, building coverage 72%, impervious surface coverage 20.6%, parking 6 spaces, loading zone 2 spaces. Those are the variances that we're asking for.
Okay. So let me ask staff, this application is now different than it was the last time we heard it. Is that correct?
Yeah, it's a little different.
Okay, there was the retail or store on the bottom or whatever that incubator
Right.
kind of space, which is not really one of the possible retail
Right.
uses in the zone. So, was there a new plan examiner's report or not really?
Yes, the plan examiner report was just issued.
Is
they-
that,
Yeah,
Okay.
right. So we worked on this last week.
Good evening, Esther Martinez. So I could guide you to the changes from the previous time that we presented. So you can get more, you could see more instead of looking yourself into the changes. So if you go to the sheet number 1, which is again, Esther Martinez, I'm a project manager associate with Tom Abilama's office. And I have been working together with Tom on the plan, so I can guide you to the changes. So we can go together. On the sheet and the title sheet, we previously present a volumetric view that we changing now to reflect the new layout of the building.
so I'm gonna ask for timeout for a second because I'm not sure I have the most current document.
Everyone should have a set that have the complete set of drawings. That is 60 pages, 11 by 17.
So I have these documents, you're talking about when you say the cover title page. This-
Yes.
6/12/25.
Yeah, there should be one other revision.
Not here. Maybe this one. Well, that's right. That's the one. Yep. Okay, pardon me, excuse me, I'm sorry.
Lucas. Is this the most current?
Okay,
Okay, moving forward. So the title sheet, which is the first page, we updated the views of the building to reflect the new footprint and the volumetric view of the proposed structure. The next changes will be on the SP 001, which is the location map and site plan. There, we also changed the rendering that it was previously submitted, which was not the proposed condition, it was a hand sketch. And the schematic section, so we chose now, instead of being 6 stories, we decrease it to 5 stories. Because on the previous submission, we have 6 stories building, now we decrease 1. And then the first floor used to be a retail and an office, and now is storage and the office space on the first floor.
Right, so
The next
I'm just
change,
gonna, it's okay for you to add, but we can't hear you, nor can the general public outside online. And so if you do want to add, you can just speak into the mic.
Thank you.
Thank you.
Appreciate that.
The next sheet is the SP 002, which is the general notes and code analysis. There we update the use group now. So we eliminated use group B because it's not going to be that anymore on the first floor.
All right, so there is no 002.
There is a SP 002, no?
Unfortunately, not in the documents we have. 003.
SP 002?
Unless it's out of order.
Didn't make it?
Well, I guess it was, I mean, this is uploaded also in the OpenGov. So the SP 002?
All right, so go to the next thing since we don't have
Well,
that.
in this case, we just have building code sections in here. So it's not related to zoning, but I want to show the updates. On the SP 003, if you have that, which is a zoning, right? There, we update the zoning analysis.
So I have to admit, I'm having a little trouble understanding you and I apologize. It's partially your accent and that's fine, but
Okay.
I do want to understand and hear what you're saying. So
Okay.
if you could just speak slower.
Yes.
I'd appreciate it. Thank you.
Correct, I got it. So on the SP 003, that sheet, right?
Yep.
We updated the zoning analysis to show the new proposal, which is 5 stories and what Jack was presenting. So the new building height.
What are you showing on 003?
On the zoning analysis, we updated that from the previous presentation.
Zoning analysis.
Yes,
Okay, does it jive with what our building department had? 'Cause-
this is the same set that the building department has, which is correlated to the plan examiner report received last week.
Okay. I mean, if, other than the fact that you've updated the zoning analysis, what did you, what changed? Maybe you can tell us, because that's what you wanted to do. You wanted to tell us what changed from the last time you were here, and that
Yes.
tells me nothing. So,
Yeah, so on the building height, we used to have 6, now it's 5.
okay,
The building height, it used to be, well, I don't have the number here, but we decreased the height, 1 floor. The length of the building stayed the same. The building lot coverage increased, I guess. Hold on one second. Yes, so the building lot coverage changed to 86%. The lot coverage changed to 96.5%. And the other change was on
well, the parking and the
no, the
loading,
parking has been the same, 16 parking since the very beginning of the process. The rear yard changed as well, because we used to have, I think 3 feet, I don't remember right now, but yes, the rear yard changed.
so is the
on the
rear
zoning.
yard increased or decreased?
Decrease.
The rear yard decreased.
Rear yard. Yeah, the rear yard decrease,
Okay.
but it's conforming because 0 is required.
So you're aware that the rear of your property abuts residential neighborhood, correct?
Yes,
Okay. And so I can tell you right now, that's a problem. If you have no setback and no buffer. So continue.
Okay, noted. Moving forward to, the next changes, which is on plan, A's 101, which is the first floor plan. So on the first floor plan, where it says now self-storage area, those areas we have labeled there to be retail space on the first floor. The office stay the same, but where the self-storage area is now used to be commercial retail space.
All right, so confused. Thought you removed the retail space. And this plan doesn't show retail space. It shows an office, an elevator lobby, a lobby, and to the west, self-storage.
Exactly. So
The first floor.
before, in the previous submission, it was retail.
All right, so you removed the retail?
Yes.
Yes,
We eliminate retail and then provide a self-storage
okay.
on the first floor.
We were gonna have separate retail for a tenant and then have our office for the renting of what you would normally rent at a storage facility. There was some concerns about traffic in the area, so we thought we were doing something good in removing that. Because I own a tech company, I was gonna put a tech incubator there to train people. Wouldn't create a lot of traffic, but would have created some high-tech jobs. That was my goal, but doesn't work for the community, that's fine for me, and we were happy to convert it to storage. And still utilize some of the space from other company to keep it busy.
Were you at the last meeting or no?
I was not.
Okay.
So
So the conversation at the last meeting
Yeah.
was not so much the retail being an issue. It was more complex than that. It was what was being chosen to be called retail.
Understood.
It was the fact that the application was presented with the retail being a bonus to get to 6 stories. And so I think, again, there's somewhat of a misunderstanding as to what was said at the last meeting and now what you've come back at. You know, it's still, you know, again, when it was originally brought to us, it was
Yeah.
brought to us as this a special permit that was granted by
Yeah,
the
the storage facility stays the same.
Right.
We're just
But-
really talking about one little spot going away. That's really the only change. You know, there's some changes to the building because of treasury bills and building costs to make it feasible to banks, which we really want to do this nice project here and bring the amenity. But there are some, you know, the world changes in 5 years. And that's what we're adjusting to really. But it'll be a beautiful project when we're done. And no change to really the basic use, which was storage and a nicer looking, it's a very ugly building now that I've left there for 5 years. I'm trying to fix it. And we just need some help from all of us working together to get that accomplished.
Right.
Yeah, and I understand this is confusing. I can see that.
So
So we'll get those things straightened out.
all right, can you speed this up? Because honestly, there's a lot of things that are not being addressed here. And the last time we met, it was a very confusing meeting as to what you were presenting, what you wanted,
Okay.
and it still seems to be in a similar disarray.
So the last thing I have here under changes is on the elevations. So it wasn't clear. It was kind of confusing where the sky was, with the parking where. So we add some property line and cars, so to figure how to make explanatory to you how the building, interface with the parking being below on the first floor. And then from the second floor to the fifth being a storage area around parking.
So what drawing are you referring to now?
Well, on the previous presentation, it was kind of confusing.
So what drawing are you referring to right?
I say elevations, which is A201.
Well, one, okay, thank you.
Yes.
I'm there.
Yeah, so we add the parking, so, and some cars, so we can figure how the property line is against the building line and the street level. And on the next page, which is 501, A501, we updated the first floor and we decreased one floor to match the application, which is 5 stories.
Okay.
So we, when we went back after the last meeting, we were reviewing the drawings based on conversation with the ownership side and the lawyer to make it more like feasible to be constructed, but at the same time, less bulky, right? Because some people here in the audience was saying 6 stories is more than, you know, and on the board, here, members as well, more than what it was approved from the city council, which was 5 stories. When this project was presented to the council, it was during COVID time, and the building was different. So they were asking for many areas that are not needed anymore because of COVID is not an issue now. And then when the client was going over finances, they figured like the square footage that it was presented to the council wasn't enough to be able to make some, you know,
Make it feasible.
feasible project. So that's the reason why we are coming after you to ask, right? For these variances, so we can come into an agreement and, you know, make it possible to all be in agreement to approve this for the owner.
I think we have to make it clear that if we get rid of the drive-through and remove a little bit of run retail, which may or may not make sense, but we could debate that on, I mean, not debate, but ask what you really want, and then come back with drawings both ways so you could pick. So you pick the one you want. We could build either one. One would require an extra floor to keep the retail, to keep it feasible to the banks. That's just the way the world is today. They won't approve a project that won't cash flow. It won't cash flow in the old design. Drive-throughs were very important during COVID. We understood that. Building costs were a little down. Building costs have increased incredibly in the last 5 years. So, you know, not just us, but any builder in the area will run into these challenges. And, you know, the building will look beautiful when it's done. It'll be storage facility. Other than one little retail store, it won't be a change to the community when it's done. And I think we have to make that clear to you because I understand we didn't make that clear today. If we have to apply for more variances again, you know, we did get 5 floors approved. We did get storage approved. I was in that meeting, at least preliminarily. Now we do have a change to the retail. That is a change.
Okay.
Question, so
Sure.
versus the original where you had retail space and then 5 stories of storage facility,
Mhm.
now you have 5 stories of storage facility. So is there any material difference in the amount of storage facility that you're actually going
Yeah,
to have in this plan?
Yes, that's a great question. We get a couple of more storage facilities where that retail was, and the banks like that that we get that space back for storage.
So you actually have more storage in this plan than in the prior?
Same square, yeah, there'll be more storage units. Yes, that's correct. Which are, you know, according to the study, are needed, so it's a good thing. And if you want less traffic on the block, it will be less traffic, you know, than a retail store, so it depends on what you really want. So it should accomplish in a residential neighborhood, less traffic should be better.
And what was the height of the original with the 6-story? What?
The 6
Yeah,
was another 10 stories height.
they're like 13,
feet.
they're 13
feet.
feet each. So was it 13, was it an additional 13 feet up or?
Yes, it was about that height. I don't have the numbers with me right now, but it was about that height. Yes, you're
Yeah,
right.
pretty much. And on this building, I think the other change was we're going to a solar roof, that's all. Solar roof? We're gonna put like a lawn up there, but yeah, that's, you know, I think it's another good thing.
Okay, so the challenge, the challenges I have
Yes.
with this are that the variances are extensive, extreme. And, and you are adjacent to a residential zoning. And honestly, if I lived behind that building, I would not be very happy that somebody put up a 5 or 6 story, let's say 5-story building.
The building's now in not good shape, and I ran his vending company
We
there for
understand.
16 years,
No,
with
listen,
100
there's,
trucks.
there's a
I'm just
lot.
being honest. I know their neighbor. I dealt with them for
I do
16 years.
too.
They're nice people, and we never had an issue. I mean, I don't think 9 feet would make a difference in anybody's view. You're not gonna have a view anyway, and that was already approved. But
It's not 9 feet. It's 2 feet, 2 stories to 5 stories. That's where you're going with this building.
but that wasn't that approved already? Am I wrong?
Yeah, I mean.
When we started the project, that was already approved.
I mean, not put the situation
So,
that this is
If
not. a-
you want to build what got approved by the city council, then present that to the building department, and you won't have to deal with these variances. Because honestly, it's a heavy lift for us to find a reason that this makes sense for the community. And, the shadows that you're going to cast on probably 3 or 4 properties behind the building. And the planning department will probably ask you to do a shadow study. And I don't think traffic is the real issue. I just think it's the massing and the bulk and the fact that you're not going to have any buffer between your building and residential properties. We already have a circumstance that happened in Mount Vernon, and it's really kind of ugly. So, I mean, I think I don't want to rush to judgment, and I don't want to be the only one speaking here. So,
Mr. Avalava, I have a question. What is the highest building in the area?
Right now, I mean, we can go up within maybe 500 feet away, you can go up story, 5-story buildings within 500.
I think the apartment building's taller than that.
Yeah,
I think it's like 8 stories. But there's taller apartment buildings right down the road that were built.
But my point is this, Mr. Chairman, is that what happened where we got it approved by the city council to come in. Please listen to me, what I'm saying.
say a word.
That we went with 5-story buildings. And we came back to you showing the 5 stories already approved by the city council. It's not the right way to come back and say, we go back to the story. I mean, that's, the city council allows you already a 5-story building. That gives you the 5-story heights. What we need to come in here and before the zoning to get it accept the fact that we're adding more. We can provide more stores on the next to it, and then turning the commercial into storage. That's all. Because of the fact the banks and the mortgages, they like to see more storage. That's all. So this is where we are standing here for, number one. Number two, the code allows 0 feet for the rear.
And most of the properties don't have that.
And the city council has already approved. I think we need to accept the fact that the 0 feet is permitted already. We can't.
So I will remind you of a situation that exists right now on Gramerton Avenue where somebody was apparently giving 100% lot coverage. Although it's so complicated, I really even hate to use this example because if you ask me, all 3 lots were not part of what went before the ZBA back when it did. And there is a building that is right on top of somebody's house. And that is not what we want in Mount Vernon. That shouldn't be anywhere. How it happened and why it happened, I really don't know. But something's wrong. And what's wrong is that it did happen. And I'm not going to be a ZBA chair and allow you to do the same thing in another neighborhood. Not, it's just not going to happen. And if the planning board can't, you know, you have a right to do it 2 stories high, then build a 2-story building. But right now, I cannot sit here and give you 5 stories on the lot line abutting a residential. So if the city council gave you permission, right, build it the way they said you can build it, and then, like I said, we're out of it. All right, is there anybody in the public or online who wants to speak? Please come forward, give us your name.
Good evening. My name is Ina Schwartz. I'm a resident on 13th Ave. So I'm not going to repeat what I said in November, but 3 additional points have come to mind.
Okay.
And many of them seem to have been addressed fortuitously in this meeting. I was going to speak to the planning council that, like, what an asset that location is. It's right the border of the Bronx. My home is 9 minutes walk to the 2 train to New York. The more affluent parts of Mount Vernon perhaps don't think of public transportation so much because they have cars, but people who have come from New York or who have seen the gentrification of other neighborhoods, poorer neighborhoods, that's how it happens, that people who recognize the asset of the location and the proximity, and this is not Hawaii, nobody is generating any more land. Land is a finite commodity, and to disregard the asset that Mount Vernon has, that the south part of Mount Vernon, the proximity to New York City. I mentioned last time that neighbors had put up solar panels. Like, the neighborhood is gentrifying, the neighborhood is improving. People who cannot afford the houses in the more affluent parts of Mount Vernon, they can afford perhaps like South Mount Vernon. So to disregard something that is a finite resource like location in favor of the commercial structure, that point was made. I wanted to make the point that I think that the scale that was being discussed, this is industrial scale, not a commercial scale. It's a block, 14th Ave to 13th Ave. That's a big block, and it goes deep. Like, I'm not privy to these papers, but when a little bit was put on the slide, like the footprint of this building, it is monstrous. And as you pointed out, the shadow. So it's like, I couldn't believe when I'm hearing now that, oh, we'll approve for 2 stories. Yeah, but for such a monstrosity, of 6 stories. And okay. And the final point is, in the previous application that was being made in November, with the bakery in a 2-story building, and they couldn't make a living. So that kind of led me to infer that, like, people making a living was a consideration. Like, that bakery couldn't make a living in a 2-story building, and they wanted to build higher. So similarly, like the point that I was making, I did not buy my home as a speculator, but you do expect people, like the citizens of Mount Vernon, to survive and perhaps prosper. Not that I'm looking to flip or anything, but that point being, like, who's going to buy a house nobody wants? As I said, I don't want it if there's going to be this monster, 2 houses down from me. Who is going to buy my house? Who is going to compensate me? Is Mount Vernon, is the city going to buy my house? Which is going to decrease in value. And so I would also like to ask, can, like, residents see these plans? Because like the more information a person has, the more thoughts a person can have about it, that this is sort of, like, I don't see what, these thoughts came to me based on
So let
the
me,
information that I have. Yes,
do you have internet access? Are you?
I do.
Okay, so, you can see everything that we see
Yeah, there.
online.
Super.
And, the way you would go about that is to go to the city's webpage. You would look at the planning, the ZBA's agenda.
Yeah.
And then you know what? I don't use that portal. So
Yeah,
is it a tally sheet like,
Those,
is it Gracchus,
those plans.
Maria or, Lucas? Where, could you direct somebody, this young lady, how to get
Of course.
there?
You would go to the city website and you would go to the date of the meeting. So today's date would be the 20th.
Yeah.
And then there's all the meeting information, and
Yeah.
at the bottom are links to all of the application materials that are presented,
Yeah.
plus the agenda there. So you can look at that.
Yeah.
And I post that at least a week or so before the meeting.
Yeah, well, no, you only received that today, these particular plans, and so what was presented in November is now obsolete. Anyway,
Well, there's updated documents now.
okay, so, anyway, the questions I was posing, they're not really rhetorical questions, they're kind of, genuine questions like what recourse do property owners have when an action of one party is going to really impact another? I appreciated that in this meeting, those points were raised, that, okay, a two-story building, well, fine. But, but 5 is outrageous. And again, the size of the footprint. So I don't want to take any more time personally, but thank you. And I would be interested in like answers or to find out.
So the
Yeah.
process works as you are seeing it. You came to the public meetings, you have a right to speak. You have a right to go online, and you should go online to find out as much information about the project,
Yeah.
whatever it might be, that is online. If a land use board makes a decision
Yes,
that you disagree with, the avenue is it's a difficult path,
like,
but you'd have to sue, basically. It's
Yeah.
called an Article 78. But it's not easy to overturn a board's
Yes,
decisions
yes.
unless the board did not proceed properly, and you can cite those. So that's the process.
Yeah. Well, again, so that first point was about the assets of Mount Vernon, it's a kind of a short-sighted view and very difficult to be undone. What if it were to be done instead of, like, again, like if somebody wanted to build a two-story like Airbnb or something for people to live cheaper, and travel to New York. But the industrial scale of this was just appalling. Thank you.
Thank you. All right. Is there anybody else in the audience who would like to speak about this application? Is there anyone online, Will? Okay. I'd like to hear from the rest of the board.
Our job is to do the minimum variances as necessary versus the substantiality. In this change, it's very substantial. So according to New York State, we're required to do the minimum, and this is way above the minimum, and the substantial amounts of the variance, it's just too great. It's too high.
So, and I'll.
Everybody would like to have, banks, even homeowners would like to have more opportunities for income. And, where does it end? We're governed by New York State law and land use, and we have to grant the minimum variance necessary. So in this case, what you're asking
So-
for is too much.
So I'll just remind the board and the public and the applicant that there is a procedure involved. There's a area variance findings and decision that guides our decision process, right? So there's 5 items on the list. And no area variance will be granted without a consideration by the board of the following factors: whether undesirable changes would be produced in character of neighborhood or a deterrent to nearby properties, whether benefits sought by applicant can be achieved by a feasible alternative to the variance, whether the requested variance is substantial, would the variance have an adverse impact on the physical or environmental conditions in the neighborhood, and 5, whether the alleged difficulty was self-created. So those are the primary tests for our process. Ms. Pintock, any comments?
I have a
Oh,
comment.
no problem.
I totally agree with Wendy. The requested variance for a 5-story is it's substantial. The parking situation is not as bad. I mean, it's Mount Vernon. Yeah, there are 2 spaces. That doesn't worry me as much as the 5-story. That to me is an issue. As far as commercial business, I mean, they have the right to be there. It's just that the size the requested variance is substantial. It's
Okay,
definitely too much.
Wandell?
Yeah, I mean, taking all of those things into consideration, the variance, I mean, is greater, much greater than 50% that we're asking for. I think the question I have is, and I think what's been stated is if this has been approved by city council, I guess the question is there a right to appeal our decision? That's the question I have. I mean, is that what we're saying?
So just so you're aware, the city council didn't approve it. What happened was the city council adopted zoning regulations to permit a 5-story self-storage building. What happened was after the city council adopted those zoning regulations in 2021, the applicant then went to the planning board. The planning board approved it.
Okay.
So that's what we're dealing with. But now there's a change to the project, and that's what triggers a variance. If they went back and just built what was already approved, they wouldn't need any variances.
So if they built the 5-story,
With the retail on the ground floor, that was the whole thing. Like they had something that was conforming to the zoning regulations at the city
At that
council.
time.
Right. So now they have something that doesn't conform to that.
Got it.
That's why they're here.
Got it.
But they could go back and just build what was approved, and they wouldn't have to come here because there were no variances
Got
with
it.
that.
And you're saying from a feasibility standpoint, from a bank finance standpoint, the 5-story with the retail doesn't work.
I think retail section, at least, they don't like retail. And if we put the neighborhood, so, trying to do it.
Got it.
I mean, so one thought, I have seen other applicants do this, is you could go back and ask city council, go back and try your luck again, see if they'll change the zoning to let you build what you're proposing now. I mean, I've seen other applicants in other municipalities do that. You know, that's always an option.
Mr. Chairman, I'd like to request an adjournment to the next meeting so that I can work through these issues about the city council prior approval, the subsequent ordinance that was created, and the effect it has on this particular application, because I think that's a focal point here. We can go back and forth on the other issues, but I think we got to get past that one first. So I'd like the opportunity to work through that. Until I came here tonight, I wasn't aware that the zoning board was looking at it in that way, okay? I'm not saying you're wrong, I'm not saying you're right. What I'm saying is it needs to be examined. I have to look into it and determine what our options are at this point in time.
Mm-hmm.
So that's the request, that you extend the public hearing, allow us to come back, and maybe this will be resolved by that time, okay? But we'd like that opportunity.
Okay.
Mr. Chair, I think that's a great idea. I think that we're all a little confused as to what exactly took place with the city council.
Yeah, no, I don't disagree that if you want another, a little
I
bit of
think we
time
have to look
to,
into that. This is a little bit unusual situation, and I want to make sure that we're all on the same page and we're all right in the sense of what
Right.
the impact of that is and, or isn't.
I
but
think
oh,
I would feel
go ahead.
better. I would feel better that way because there is a bit, it is a little unclear for me
Okay.
with regards to the 5-story, 3-story. So, yeah.
So that's the request.
Okay. With that being said, do I hear a motion to adjourn to the next?
Second.
The
Public hearing?
the February meeting, is that correct?
Yes.
February 10th?
February 10th, yeah.
Thank you.
So there's a motion on the floor to adjourn to February 10th meeting. Is there
also a second.
Second?
Second.
I didn't hear it. I'm
Yep,
sorry.
second.
So there's a second, and then on the motion, all in favor?
Aye.
Aye, everybody has agreed. It's 4 ayes, no nays, and 1 vacancy. All right, thank you.
Thank you.
Okay. All right. Guess I really need to figure this shit out. Okay, continued public hearing. Case number ZB 24-16, 127 South Terrace Avenue, section 164-84, block 1061, lot 17 in the CB Commercial Business Zone. The board previously received proof of mailing, proof of publication in the Journal News, and proof of initial sign posting for the application. The board also received an affidavit of sign posting about our meeting today. The board also received photographs showing the sign posting. The owner, John Ruggiero, is represented by his architect, Shaheen Badali. The applicant is seeking to obtain area variances for the conversion of an existing commercial building to a cannabis dispensary. The subject property is 9,450 square feet. It's located on South Terrace Avenue off South Street and Grove Street, and is located in the I industrial zone near South McQuestion Parkway. Area variances, local proximity to house of worship. Required is more than 500 feet. Proposed is less than 500. Location of sign is proximity to the playground. Required is more than 500. What's proposed is less than 500. And the parking, 10 spaces and 1 loading space, and proposed is 9 spaces and 0 loading spaces. So 10% on the parking and 100% on loading variance. The applicant has been sent to the fire department, police department, and the city engineer for comments. The application is not under the jurisdiction of the county planning board. Secra, the proposed action formerly required a use variance in an earlier incarnation of the application and was classified as an unlisted action under Secra. The zoning board of appeals declared lead agency on the application at its September 19th, 2023 meeting. At its November 20th, 2023 meeting, the zoning board referred the application to the city council for a zoning text amendment. On January 24th, 2024, the city council adopted a negative declaration regarding its uncoordinated review of the unlisted action and enacted local law number 1-2024, a local law to amend chapter 267 zoning of the code of the city of Mount Vernon to regulate cannabis retail dispensaries and consumption sites. In light of this code revision, for the purposes of the zoning board, in light of the code revision for the purposes of the zoning board, the proposed action is a type 2 action under Secra based on 6 NYCRR C18. Reuse of a residential or commercial structure or of a structure containing mixed residential and commercial uses where the residential or commercial use is a permitted use under the applicable zoning law or ordinance, including permitted by special use permit, and the action does not meet or exceed any of the thresholds in section 61.4 of the part of this part, therefore ending the secra process. Okay. That was a mouthful. Good evening.
Good evening, Mr. Chairman. Good evening to the board members. Good evening to the city staff, Corporation Council. My name is Mark Blanchard. I'm with the firm Veneruso, Curto, Schwartz, and Achinelli. I am an attorney for the applicant. I'm joined here by my colleague, Stephen Achinelli, also an attorney on the application, by our architect engineer, Shaheen Badale, and by our traffic engineer, Kevin Masio Vecchio. Give it up. All right, I got that. I've been practicing that all afternoon. So he's from JMC Consulting. I'm also joined here this evening by the owner, Mr. Ruggiero. The owner representatives are here with me as well. So we're here, of course, to answer any questions. But before we do that, we have some notes, some presentation we'd like to give to the board, some information we want to share.
Okay.
In reviewing the minutes from September and in reviewing the updated application review and the determinations, it's clear that the board has 3 issues in front of it that are concerning, or the 3 biggest issues, I should say. Of course, the first one I would say would be parking. Next, we have the variances that are that have to do with the proximity variances with the sign and the house of worship. And then we also have, unrelated to the review, but brought up many times in the meeting, we have an ownership issue relating to the operating agreements and the ownership structure. So we're here to answer all 3 of those right now. Respectfully submitted, I'd like to start off first with the parking variance. I'd like to ask Kevin, well, before I ask Kevin to come up, sorry. A comment was made at the last meeting, and though the board did not require it, the owner on his own initiative went out and initiated a traffic study. So we have the representative here from the JMC Consulting. We had an on-site individual go do the traffic study. It was actually part of this submission that the board has in front of it. The board saw that data. But rather than have me relay it to you, I'd rather have the engineer get up and explain what that data means and what the parking count shows. I'm happy to report that at the conclusion of that presentation, the information, we're going to be able to show you that the parking, what's on site right now, offered to the consumers, offered to the public, actually meets and exceeds what the demand is showing. Obviously not what the code requires, because we're here for a variance, but the demand on that consumer location is well satisfied by what's existing on site. I'll even say, just as a side note, just for context, the parking is affected by a residential construction project across the street from this location. As everyone who's familiar with the location, half the street is, they're sort of fighting this with one arm tied behind their back, right? Half the street is closed off with barricades and a very active construction site across the street. The Elevate Cannabis location helps. They're very good neighbors to the construction site. Some of the construction members come in, they use the restroom. Sometimes they're able to jockey the parking and allow for a larger construction delivery truck to come in, back into their site, come back out. So the neighborhood's very cooperative with each other. But it just goes to show, in sort of the context of what's happening right now, practical on the ground, the parking is such that they're able to have flexibility on site to assist in their other neighbors. I just add that as sort of contextual history here for what's happening right now, boots on the ground as a practical application. But without any more from me, let's have Kevin come up and speak to what JMC found when they did their parking study. He'll show you what they did, the counts that were, and what the conclusions they reached. Then I'll come back.
Good evening, Kevin Masiavecchio from JMC. So what our office had performed, we spent 2 days out there at the site from 9 a.m. to 3 p.m. and then from 4 p.m. to 8 p.m. in November on a Friday and a Saturday to get typical operations going. Pretty extensive amount of counted hours, 10 hours each day. And we counted in 15-minute increments. And we did provide in the packet, there's a nice summary table, which I can put a board up as well, but it should be in your packets, which what it does show is in all of these increments, all these data points and metrics, the average parking demand that was needed throughout the time period was 3 parking spaces. And there was a peak, the peak periods, it was 6 on a Friday and 7 on a Saturday, which is still below the parking that is parking supply that is available to the consumers and on the property. So this is all the parking that's provided on site is sufficient to accommodate the daily use of the property. And there's no need for the customers to park on the street or even look at the street parking, which, as noted, is currently being affected by the construction. And so while we were there doing our counts, we noted that there's everybody was parking in the spaces. Nobody was parked illegally, double parking because there was sufficient parking. And while we were there, there wasn't inclement weather that occurred through our counted periods. There was some rain overnight between Friday and Saturday, but nothing that would have affected the operations or consumers who were approaching the facility. So kind of in summary, as already stated, is there's sufficient parking is what we're finding for the use that's provided on the property to the consumers.
Just a question.
Yep.
So Elevate is open until 11 PM on those nights that you were there. So why did you end at 8 PM and not go like
Just
up
kinda-
until the time it closes?
And even as you look at like earlier in the day, the time periods start to drop. The busyness early in the morning is not as busy in the parking, and then as we've seen as some other properties, and after 8 PM is when the busier hours start to drop off again. So we thought we had seen the peak hours, and that's why we didn't keep counting all the way during the operational hours.
So the peak is at what time?
So what we were seeing was the peak was in the 6 to 7 PM range.
Okay.
Is when we were getting there was a 6 vehicle and a 7 vehicle, which was still, well below the supply.
And then what's your expectation once that construction is done on that other side of the street? What will the parking situation be? Is there, I don't know if you know, or you can address that?
So we have enough parking on site, so there's no need for the off-street parking to be used by the proposed use. So even if there's more availability on the street, it could just be used by the surrounding community.
Yeah, so it's hard to tell with the construction that's going on there, what's is there gonna be a curb or?
I'm not
You
sure
don't know.
with at this, it's not us doing the proposed improvements, but
Mm-hmm. Okay, thanks.
I think thank you for that question. I think to follow up with that, we would presume, since we are self-sufficient in the parking we're providing to the consumers, whenever the barricades or the construction of the restrictions on the other side of the street are lifted, it would help alleviate anyone that's in the neighborhood that was being affected by just the on-street parking that's been taken away. So I really only see a benefit happening to the neighborhood itself. It's not going to affect our business, but to the neighborhood itself, they'll experience a benefit. Because those restrictions will be lifted. The other issue that we wanted to bring into this, now that we're looking at the parking calculations.
So I guess I have a question or two about the parking study. So, so can you explain the weather a little better on that Friday and Saturday? Because was an observation by someone in the public, which I'll be reading their comments into the record at some point, because they requested that, that the weather was quite inclement, windy, heavy rain. Can you speak to that?
yeah, we have photographs we can put together, we can put together that in a future submission packet, but while we were there performing the counts, there wasn't any heavy rain or any flooding in the area that would have affected consumers showing up to the property. It did rain overnight between the Friday and Saturday because we counted Friday and Saturday consecutively. And then when we were on site again on Saturday, the ground was wet, but there wasn't any ponding or anything that obstructed the use of the parking lot. So there wasn't.
Okay, so there was
There
no.
was weather, there was rain, but we didn't.
So let's clarify it.
Yeah.
Was it raining only overnight and not the next day and not during the hours or was it raining during the hours you were there on both Friday and Saturday?
We didn't have rain while we were performing the count.
Okay. That's what I wanted to clarify.
Thanks. So thank you for that. And just to supplement on what Kevin just said, I saw that comment that was submitted later in the day. We are disputing the assertion that there was weather-related impact to the parking analysis during the day on Friday, during the day on Saturday. We're not experiencing rain on the site. It was an overnight rain. And even on Saturday, with maybe the asphalt was wetter, there was some puddling. There wasn't pooling that was preventing anyone from coming on and utilizing a spot. We have no complaints of any stormwater issues on that site. So whatever had to happen overnight on a rain event did not affect the parking the next day. Part of the variance application is, of course, not just the number of spaces, but the loading dock, the loading space issue. I think what's unique to this particular use is the utilization or the need for the type of loading space. The cannabis industry, you don't have the delivery in your typical UPS truck or an Amazon truck or a larger box truck or even an 18-wheeler. These are kind of boutique or deliveries in a personal vehicle, maybe a minivan, something along those lines, where it's more of a much low profile product, where maybe one individual walking in a bag or one container of product. So we're not getting some kind of a large scale delivery that would require a turning radius for a truck on site, that would require a striped, much larger loading dock that you're used to at other larger retail locations. And
Elevate has other locations. At their other locations, do they conform to having a loading dock and the parking spaces?
I'm sorry, could you repeat that?
Elevate has 2 other locations, is that correct?
In Mount Vernon, there are 2 other locations in close proximity that are not owned by the applicant, no.
No, but Elevate does own other stores in Westchester?
Oh, well, there's at least one more in White Plains, but I think the issue is it comes back to the size of the lot, the size of the affected parking area. You know, I think, like, for example, I'm familiar with the location in White Plains where it's a much larger location. If you're able to put in, if we could have put on a loading space here on this site, we would have been happy to do so. But we're happy when we look at the configuration of the site and the square footage that we have, it helps us with our operations where we can say, we don't need to back in an 18-wheeler. You know, we need a spot for someone to pull in their car. Almost like, sort of like akin to like an Uber Eats delivery. I mean, I'm not saying that's what it is, but it's sort of something like that. Like the personal vehicle will show up, make the delivery, be there for a short period of time, and then go off to their next delivery. So I think that's significant here because, of course, when you look at the area variance test, the chairman noted on the previous application, the 5-part test, the first one has to do with the substantiality of the variance request. And what we're happy to report with the parking issue is when you look at the parking data that's been presented and you look at now the need and how the loading space is utilized, I think we're able to say with confidence, full confidence, that it is not a substantial request. We are self-sufficient with what we have on site, loading space and consumer demand, right? So in terms of the data proves out, not only just the JMC data, but the site has been open since December of 2023 and fully operational. So we have now engineering data and we have 2 years of historical context to make the argument that the balancing test for the first prong, the substantiality, weighs very much in favor of the applicant. When you look at the second 2 prongs, they're somewhat related. If you grant the area variance related to parking, will that result in a detrimental environmental condition and will it result in a change to the character of the neighborhood? Again, we're fully self-sufficient, so you're not seeing any queuing out into the street. You're not seeing any double parking caused by our consumer need. There has not been a litany of complaints into the building department from your residents. There are no open violations. There are no police department complaints relating to parking or queuing or double parking. So when you look at the character of the neighborhood, how will this be affected by the granting of the variance? Will it result in a detrimental change? Well, I can say with confidence, the board is well within its discretion to find that the record fully supports that the balancing test weighs very heavily in favor of the applicant. Was it self-created? Perhaps self-created. Many variances are. It's why the state law does allow you to say it's not dispositive. Even if you do find it self-creation, it's not dispositive. But again, the variance itself for here, the self-creation issue, I always sort of bristle at because it brings it back to the self-creation really has to around us, but that's not really realistic. That's not feasible. And is there an alternative method to try to achieve this variance? We really have squeezed out, Mr. Baddeley has gone back to the plans. He's squeezed out as much parking as we can. There really is no alternative. We're not picking a fire pit or a little, an outdoor seating area for something. We didn't pick something over this. We've tried to maximize the parking that we could on site. So we don't have a feasible alternative. The self-creation issue is mitigated, right, by the circumstances surrounding the size of the lot. And I'd argue with all due respect that we're in very much a unique position here when you're looking at this particular application, because as a practical matter, for the application, this board having sent the applicant out to the city council, right, for the code amendment, the city had been contemplating this anyway. It was all over the state. Now, Mount Vernon was one of many cities to quote unquote opt in to the cannabis legislation. Because the applicant has been open since December of 2023, and the city council took its legislative action in February of 2024. I'm not saying from a legal standpoint, but from a practical standpoint, this application has essentially transformed into something more like a legalization application and not necessarily, I'm not standing here with my crystal ball like I usually do and say, hey, well, these future impacts are mitigated, or these future impacts you can rest assured are not going to be severe. This is what the data shows, and I'm asking you to extrapolate and look into the future with me and say it's going to be okay. We're sitting on 2 years, more than 2 years really, 2 years of seamless operation within the community, of no complaints, of no city enforcement actions, right? I mean, well, there are complaints. There are some people who are opposed to the project, but I'm talking about building department violations, building department complaints, inspections, surprise inspections, things of that nature. We're really looking at this. I respectfully argue that the board is looking at something that really has transformed into this more closely aligned with the legalization than it would be on some kind of a prospective future variance application. So when you look at all this information compiled together as it relates to the parking variances, I respectfully submit that the balancing test weighs very heavily in favor of approving this already up and running operation. My second point, if there are no questions, the second point has to do with these proximity variances. And in very rare instances, and my principal point's brief. Sure, Mr.
Hold
Chairman.
up a second.
It's up to you, whatever you want to do.
No, I just want to stick on the parking thing, one last little comment, and I'm sure you're aware of the comments of this board and some of the concerns about the second floor and the separate building where there was a body shop, and just moving forward, whether those facilities or that space will ever get utilized. So initially, when the application came before the city, there were many more parking spaces that were required because of the upstairs
Correct.
office space. And subsequently, I guess some internal conversations, I'm not totally sure why it changed, but it changed after that. And so there's still that concern on the board as to making sure that those spaces are not utilized. And if they are, there needs to be something put in place to accommodate parking that would then be required.
Happy to address that, Mr. Chairman. Happy to address it. And,
Okay.
I think what allows us to address that question with confidence. Well, first, let me back up. I understand exactly what the board is concerned about. You look at that second floor, God bless you. You look at that second floor of that building and there are, bless you. If you look at that second floor of that building, there are a lot of opportunities to go up and utilize it for something else. But it, just like in sports or like the Giants or the Rangers or something like that, success helps you guide what choices you're going to make with your organization. And the cannabis dispensary use has been so successful there that it's quite, it's within the operations to just, as has been stated, as this application has evolved, the upstairs portion of the main building, the two-story building, is only used for storage. It can be used for office space. It's not going to be used for office space. The building was purchased. It was formerly used as office space. That has been decommissioned. So as has been stated on the record, and I'm happy to repeat it on the record, that upstairs space is not going to be utilized in any way that is going to trigger a new parking requirement. And I'll even add this, Mr. Chairman, sort of to dovetail off of what you just said, sort of repeat what you just said. If in the future, the owner decides to re-engage that space and use some offices or whatever it might be, we are fully aware and fully agree with you that we would have to go back to the building department. We'd have to do it for a building permit anyway. We'd have to trigger building department review, and we would have a new parking obligation placed upon us, which would find us right back here, because like I said, we don't have a lot of room over there for more spaces. So we fully agree with you. And the same goes with that detached one-story building. It's not used as a body shop now. We're not using it. It's not used in connection with the business. If it's ever re-engaged and reutilized, we fully understand that just like the second floor, that detached one-story building will also be subject to building department review and scrutiny. So that's on the record. We agree with you, and I'm happy to put that issue to bed.
Okay, and I have one other question. You mentioned about the fact that there's been 2 years of operation and things are successful. They've not been cited for anything. And you mentioned building inspections or surprise building department visits. Can you tell me if the building department has been there for either surprise visit or a regularly scheduled inspection of the operation in those 2 years?
Yeah, absolutely. The building department has been there for issues related to the certificate of occupancy. I think Mr. Ruggiero, the last time on the record, acknowledged that there was an inspection, and within 24 hours, he had taken corrective measures. I'm talking about there hasn't been parking. We're here in front of you for the variances, and I'm trying to present an argument to this board that the variances we are seeking are not substantial. One way that I'm doing that is by showing that the variance that we're asking for hasn't triggered enforcement actions, specifically parking on the street, parking illegally, double parking, things of that nature. So I was perhaps imprecise in that description. Yes, there is building department activity. We're still getting the certificate of occupancy. There are no open violations as I'm presenting. The building department, the owners have been nothing but cooperative with the building department. There have been inspections. Corrective measures have already been implemented. And that was put on the record in September. So forgive me for being imprecise there, but if I could narrow it down or distill it down to the essence, is that the proposed variance is not triggering any kind of enforcement that would lend this board to think that it's a substantial requirement from the city. So in fairness, the parking, the loading space, the upstairs space, the ancillary one-story building, I think we are all on the same page here. I believe we're presenting enough information to satisfy the board. When it comes to the two proximity variances, in very rare instances, and New York is a wonderful example of what's called municipal home rule. There's a lot of state enabling legislation that allows municipalities, like your requirement for a sign on a ZBA application is different than your neighbor Yonkers and New Rochelle and Eastchester. So there's a lot of state enabling authority that allows the municipalities to operate with their own discretion. In rare instances, will the state walk in and say, we are preempting you. We are going to take over this issue so that we have statewide uniformity. And the issue of the cannabis legislation, just like in the issue of alcoholic, like the age of consumption or cigarette smoking, or even if you have like a gambling regulations, right? Gambling is very heavily regulated by the state. The cannabis industry is heavily regulated by New York State The preemption issue here has to do with New York State has issued regulations that don't leave any room for the municipality. They have preempted the municipality. For example, the city of Mount Vernon, like other municipalities, city of Mount Vernon adopted a 500-foot distance to a house of worship. The state walked in and said, no municipality is allowed to adopt a rule preventing the approval of this type of permitted use within 200 feet of a house of worship.
Mr. Chairman, point of clarification, and I believe this issue was raised by the board in a work session. On that issue, and I point to page 3 of your proposal, where you indicated that under the preemption doctrine, that the city council's adoption of the 500 feet within a house of worship was impermissible. I tend to agree with you on that, but I need clarification with respect to point B, where your argument is that the distance of 500 feet as set forth in the city code are preempted by the state legislative distance of 200 feet to a house of worship. That's correct, but council, isn't that incorrect with respect to a school or a playground? Is it 500 feet?
Well, no, you're correct, counsel. I do need to clarify that point. And the clarification, I'll send you the regulations, 9 NYC.
Well, you don't need to send me the regulation. You just need to clarify whether or not, with respect to a school or a playground, is this factually incorrect, what you have in your papers, that it's in fact 500 feet and not 200 feet?
It is 500 feet, but it's not, but the city,
Or you are seeking a variance
no,
on
well,
that
no.
point?
Well, hold on. I'd like to finish.
Okay.
The city has 500 feet to the boundary line of a playground or a school. The state regulation is 500 feet to the entrance of a school, not the boundary line. So it's the city's ordinance is not in compliance with the state law. That's why I was offering to send you the regulation. The state law is very specific. That is only to the entrance.
The board will need to take a look at that because it seems that that issue with respect to the distance from the school is in controversy to the extent that you're claiming that it's 200 feet. And
It's 500 feet. We can clarify that on the record.
so the city ordinance is legislatively permissible, correct?
No, it's not correct. The city ordinance is 500 feet to the boundary, any boundary of a school or playground property.
Okay.
The state ordinance is more restrictive. The state ordinance says it's a 500 feet, not to any boundary point. It's 500 feet to the entranceway, the entrance to the school. So that is more restrictive than what the city has adopted.
Not necessarily.
Let's be clear. What is the distance?
The distance is 500 feet.
No, that's not my question. My question is, what is the distance with respect to the location of the signage proximity to the playground?
Well, the signage, the issue regarding signage, the city is preempted. I'm sorry, this does deserve clarification. The location of a cannabis dispensary is 500 feet from the entrance to a school. That is not here what is in dispute. The city has a sign ordinance saying the sign itself cannot be within 500 feet of a boundary line of a school. The sign ordinance that the city has adopted, and this, I was going to bring this up. This is a point of clarification. The sign ordinance that the city has adopted has been preempted by the state. And the sign ordinance, the proximity of a sign ordinance, and I'm happy to submit a supplemental letter to you, but the proximity of the sign ordinance is not included in the state law. The state law lists an exhaustive list of areas that it has left for the local municipalities to regulate when it comes to cannabis. For example, The local municipality may regulate an hour of operation for the cannabis dispensary. It may also regulate hours of operation of on-site consumption of product at a dispensary. It may also regulate a visual or architectural integrity of a dispensary if that dispensary is in a historical district. So the state is preserving a historical district. The municipality is also free to regulate the parking requirement of that commercial business. That's why now we have come back to the 10 spots. The municipality is also allowed to regulate odor and regulate noise. But when it comes to the municipality entering a restriction on the placement of a sign, because the state did not delegate that authority to the municipality, that sign restriction in and of itself is preempted. It's a rule that the state does not allow the municipality discretion to adopt. And I'm happy to provide a supplemental opinion to you so that you can see where I'm coming from with that. But that point of the clarification of the distance, I don't believe we need a variance, but we will clarify that for you. But even in the alternative, since we're all here to be most efficient, even in the alternative, we would argue, and I do argue in my brief, that even in the alternative, let's assume arguendo for a minute, that we do need a proximity variance to the entrance of that school. The fact that we have existed for 2 years, there haven't been any complaints whatsoever by a parent, a school board member, a member of the community that relates to the school, other than what we have on the record. But in terms of a complaint of someone who is using that school, we have not seen any complaints that would weigh the balancing test
So
in favor of
I
denial.
need to clarify something, because you keep talking about school and tell me if I'm wrong or not. This signage and location is not within the proximity of any school.
It was identified, I didn't find a school on the map either, but it was identified on your
Let me
review.
continue, because you.
I'm
keep-
sorry, Mr.
You
Chairman.
keep talking about school, and that's not really pertinent to this application. It's playground and it's house of worship. So.
Yeah, okay. Well,
and
the school and the playground were together. I'm sorry, sir. I'm sorry, go
The
ahead.
school and the playground are together?
In the state legislation. So I keep saying school, I mean to say playground.
Okay. So then we need to see where
Right.
the state is.
That's my
Is
concern.
converging both the school and the playground in one, because, the notes I have that the state just opines on, church, school, and proximity to another cannabis dispensary. If playground is one of them, then, we surely will need to determine whether he is correct about our local, we don't have home rule on this particular.
Well, it's understood that if it's a school, then it's 500 feet. I don't think that's in dispute. The issue is this location within 500 feet of the school or the playground?
Well, it is
Right.
within 500 feet.
Then they need a variance.
Okay.
Excuse me, it's 500 feet. Your review listed it as 500 feet to the proximity of the boundary line of the school or playground property. That is incorrect. That is preempted.
Right, he's saying the state overrides.
Yeah, the state overrode
municipal.
that it's not to your rear property line of a playground or a school. It's not.
All right, but we need to see that language, because clearly, if it is what it is, and if it's not, I don't see it. If you present it to us, as an excerpt from the state law, I've missed it. And so we will need that, or you can point me in that direction, to save us.
I will. In my brief, I include the citations to the state regulations. I'm happy to submit a supplementary submission to
Okay.
you on this one particular issue. But I would argue that this one particular issue of a sign proximity to the entrance of the school is a much minor, very much. It is a minor issue in terms of the overall
We're-
application.
We're not making that decision one way or the other. I
Okay.
just want to make sure we're clear on the law, and you've spent 15 minutes discussing it, and that's great. But until I have some more specific knowledge and feedback from our legal counsel, clearly you spent the time to discuss it. We want to spend the time to
Sure.
to look at what you said, and if you are right, and we may very well, if agree with you, and then say, well, it's minor and we grant you the variance. So that doesn't preclude us from going there as well.
No,
So
I'm
we
not-
just
I
need
think-
to,
Sure. I think moving forward, as a point of clarification, I think we're on the same page that a preemption issue exists here, that the house of worship, the city's interpretation of the house of worship is preempted by state law, and the board needs clarification on the proximity of a playground to the sign. And we're happy to, I just want to narrow the issue.
Right.
And happy to narrow that issue and do a supplemental letter as it relates to the sign in proximity to the playground. Well, the school and the playground were listed, enumerated in the same statute. That's why I said that. But we'll limit the focus to the playground. It'd be the playground proximity to the sign. And I'm happy to show the board our position that the city was preempted in that instance as well.
So can you just clarify, when you talk about entrance to the school, what constitutes the entrance boundary? Is it the pathway leading into the front door? Or is it the front door? What is the entry point?
The entry would be measured to the property line where the sun, let's say they're, on a typical school grounds, it'd be like a grand entrance, right? You have a nice front lawn or something to it, or if it's closer to the sidewalk, whatever it might be. There's one way where people from the sidewalk will congregate or form and enter into the building. We would measure to the property line where that would occur, not to the doorbell,
Okay.
but we would measure to the property line. The property line is what's significant here, because I'm showing the city that there's a differentiation between entrance or any point on that property line, right? That's disadvantage to me if it's the property line at any point, because you could go to the rear and that's where you stop measuring. But if it's specific to the entrance, then that adds into, it all depends on where the building is sited, but we have to be in matters of preemption, you have to be very specific. So that's why I'm drawing you back into exactly what the state law says, because it's an unusual move by the state to preempt a municipality in New York State. That's why I was saying earlier, it's a very powerful home rule state, and this is an unusual circumstance. So anyway, look, I think we have gone through the parking, the spaces, we have gone through the loading zone space. I've argued that the balancing test weighs very heavily in favor of the applicant. We've gone through the preemption issue, one that it exists, to that the proximity to house of worship. We will provide supplemental information as it relates to the entrance to the playground. And then the third and final issue has to do with the ownership structure for the applicant. A concern had been raised, and I do find this requirement a little unusual. I don't see it in other municipalities, but Mount Vernon requires the operating agreement, right, for the owner. And so I think we have clarification for you on that issue. The original application as submitted by Mr. Baddeley was that the South Terrace Auto LLC was the owner of the property. They are the deeded owner of the property. And this board has the LLC agreements and the operating agreement for that South Terrace Auto LLC. What we have on the property, you then received a copy of the Elevate LLC. You have received the operating agreement for Elevate LLC. They are the tenant at that property. Elevate is doing business. You see you received a copy, and I have copies for you if you haven't. A copy of the cannabis dispensing license issued by New York State is to Elevate LLC, doing business as Elevate Cannabis. So Elevate and Elevate Cannabis, the current owner, the current tenant operator on that property, they are the tenant. Mr. Ruggiero is the managing member of Elevate as owner of the tenant. Mr. Ruggiero is also managing member of a two-partner LLC when it comes to South Terrace Auto. So you have the auto, you have the owner, you have the information as it relates to the owner, you have the information as it relates to the tenant, and you have the operating agreements for both. What you don't have, or what I would recommend, or maybe what I would suggest, not recommend, but what I would suggest is as making it a condition of your approval, should you decide to approve, is when for the issuance of the final certificate of occupancy, Mount Vernon also requires, if it's a tenancy, not an owner, Mount Vernon requires a copy of the lease and that the tenant apply for a certificate of tenancy. So let's assume for a moment that this application is approved. Then the next step is for final certificate of occupancy, or one of the next steps is final certificate of occupancy issuance by the building department. At that time, the lease, those documents would also be presented to the building department, and no final certificate of occupancy would be presented until such time that the applicant showed the building department exactly what it is you're asking for. So I think from my perspective, that alleviates the board's concern as it relates to ownership, right? We have to prove to the city who the owner is and who the tenant is, and also show the lease. So just to review, you have the LLC documents for the owner, the deeded owner. You have the operating agreement for the tenant. What you don't have is a copy of the lease, but you didn't ask for that. But the building department is going to get a copy of the lease when we have to do a certificate of tenancy and a certificate of final occupancy.
Does the lease apply also to the auto body, that separate building?
No, that's a separate use.
So it's a separate use. Who is the leasee or the owner of that?
You're talking about the one-story ancillary building? That's not being used currently as an auto body use. I
So-
believe that's the same owner, the South Terrace. Yeah, it's the same owner, South Terrace LLC. You have the documents for that one-story building. That is the same owner, the deeded owner of the two-story building.
Oh. So they're connected.
So hopefully that assuages the board's concerns as it relates to this ownership picture. You have the ownership documents for you have the corporate documents for the owner and the tenant. And by the way, Mr. Ruggiero, who's here this evening, he is involved with both, and he's, so if there was a question as whether or not an authorized representative was here, I think you'd be satisfied that we're fully authorized to make this application.
So all that is I need an org chart to really make sure I understood what you said. So I don't know why I don't have this information in front of me, but and that could be my fault because the revised documents didn't get to me in time, maybe for me to do a true.
Oh, sorry, sir.
I'm sorry, I'm fading off because I'm
I'm
unsure of what I'm saying. I do need in writing and copies of the lease, copies of the LLC, and explain to me in brief, not me, the board, this ownership thing and the license. Okay? Because you said a lot in a period of time, and for me to follow it, I need to see it in writing. Okay?
Submit an org doc. This is no problem.
Yeah, no, the license, copy of the license, who the license.
I can submit that now. I have it with me, or I'll submit it with our submission.
Yes.
Bless you.
Bless you.
Bless you.
Yeah, I think for me, an org chart.
So
would be
I
great.
do have a couple other things. So, you mentioned they operating for 2 years and there were no complaints. And quite honestly, there were some complaints, and maybe you're not aware of them. There were, unfortunately, maybe not, those complaints were not necessarily addressed by the city. I have a copy of an email here, if I could find it. Back in July 9th of 25, that, I mean, basically there were a couple of complaints. I'll have to dig up the actual, there was, there were things that were going on that really were not permitted to be done. Parties in the street, and I understand the promotion of the business is important, but so there were things that were going on that really were not permitted or and were complained about, but there was never really any action from the city. So unfortunately, there's no record of it.
Well, but Mr. Chairman, and with all due respect and in all due fairness to the owner, you know, my client is entitled to due process. And he's entitled to equal protection.
I'm just
A due pro-
responding to your statement that they've operated for 2 years and there's been no complaints. So that's my comment.
Well, but
That's the beginning of it and that's the end of it.
I just want the record to reflect. I appreciate your comment. I'm not trying to be disrespectful, nor am I trying to be overly argumentative here. But when I'm standing here from a due process standpoint, and I'm thinking about the word complaint, and I'm mired in city enforcement, I'm not talking about if someone sends a random email 8 months ago. I'm talking about is the building department responding to parking complaints, right? I need to show you the balancing test weighs in favor. I'm talking about things that are given, that are articulated, where my client has fair notice, where he has the due process, where he can respond, where maybe there's a hearing. Those complaints, the record doesn't have any of those complaints. I didn't mean to imply that someone didn't fire off an email here or there, but in terms of adjudicated complaints, the record is empty.
Jed,
If you want me to read it into the record, I can.
okay, I'm gonna, I really need to make sure I articulate my point, and I'm not gonna do that right now at 8:20. So I will do the research and we'll put it into the record, and it'll just be in a record, and you guys can address it or not. It doesn't necessarily matter, but it's just important that we understand that, you know, there have been concerns expressed, and unfortunately, from what I can see, not really acted on by the city. And I guess you can say, well, then my client doesn't have anything to worry about, and
No,
they don't
that's
necessarily
not what
have
I'm
anything
saying.
to worry about. But it's important that the record be straight, that not you just standing there saying they've been operating for 2 years and there have been no complaints. And I know you were trying to say that in reference to parking. There is a complaint just that came in where somebody drove by the operation this weekend, I think, and there were this car parked on the sidewalk. What does
Okay,
that mean?
but
I mean,
but-
does it,
Hold on.
what?
Oh, yeah, we did see pictures of the car that was on the sidewalk was a Mount Vernon police car. But Mr. Chairman, I get what you're saying, that people fire off emails, but it's important that the record also reflect. I have to stand here and protect my client's substantive due process and procedural due process rights. It has to go both ways. Someone can shoot an email and I'm not happy with what's going on down there, but that shouldn't impair my client's quiet use and enjoyment of his property. I mean, that's not, that, it has to be fair. I'll recognize any email that was sent and we'll address it. We'll put it into the record. But I want the record to also be clear in terms of due process. My client hasn't been subject to any violations. My client hasn't been brought into city court. My client hasn't had to defend himself against an allegation.
That's fine. I'm not-
That's a huge distinction.
Can I interject? Can I interject here? I think the difference, the distinction and the difference here is you are saying enforcements versus complaints. And those are two very different things. And I understand that. So I just don't want us to get caught up in semantics at 8:20.
Okay.
Because you're talking complaints, he's talking enforcements from a legal perspective versus a civic perspective. So that's all.
Thank you.
Fine. Okay. Are you done?
I would just like to say, I think that I think we've advanced there's been a lot of open-ended things. We have not been back to you since September. We've done a lot of work to try to clarify this. I'd like to request that the board, see if it would contemplate an approval posture, or at least a decision or disapproval or approval, a decision posture for the February meeting. This has gone on quite a long, from my perspective, I think with the Corporation Council, we can resolve the state preemption issue fairly briefly, maybe. I don't think it's not gonna take a war and peace to show this one point. Of your perspective, you have something else you want to clarify regarding complaints versus enforcement, but I'd like maybe the board to start thinking about a resolution for the February meeting. I think we're very close.
Yeah, that's Fair enough. We do have legal counsel that needs to opine on the state preemptive issue.
Yeah.
And beyond that, if there's anybody in the audience that wants to speak to this, I don't really see anyone necessarily other than your people. So is there anybody online that wants to address the application? Okay. And any other board member have questions or comments?
I
at this
do,
point?
Mr. Chair. I think this has gone long enough. Unfortunately, we're 2026 now. This started way back in 2023, if I'm not mistaken. It was something that city council did pass a law. And unfortunately, back then, I'm sure we didn't have all the regulations for cannabis in place. So there were a lot of, I guess, things that should have happened that maybe didn't happen, but we're here today. And I personally feel that the playground is not going to go away. So it's not something that we can change. The church, the house of worship, I can't even speak today. Based on what I understand is a tenant of the location, which means that they could be there today and be gone tomorrow.
That's correct.
So that is something that can certainly be cured. It's not, to me, it's not a big, I mean, it's there. There's nothing we can do about this. So yes, I don't know that the proximity of the playground versus where the cannabis is going to make a difference on the decision that we're making based on this application. So that's my take on it. Again, yes, I myself have gone to the site and I have sat in my car. I have not gone into your establishment. Maybe I will go visit it. But I have seen that there has never been, when I've been there, which has been several times, anyone waiting for a parking space. I've seen people go in, few minutes, come out. So that's been my view. Again, that's my own personal take on this. As far as complaints, this is the first time that I hear that there's been a complaint sent through an email. I did not know about it. However, if it's a parking issue where someone either double parks or triple parks, it happens in Mount Vernon everywhere. I don't think that's a big issue here. Again, my personal opinion, this is me speaking. So I am personally ready to move this application forward. And that's
Look,
my take.
Can we do it with consideration or conditioned around use of the second floor and an ancillary building? Because those are opportunities to create problems.
That was another question that I had for the tenant of the cannabis place. I understand that you do have some promotional events. I don't know how often you're having these events. If you are having these events, which is fine. Every business should and could have these events. My question is there enough notice of it? What do you do? Do you have valet parking for these events? What is it that you're doing?
After the last event was an issue, we haven't had
Can't understand you.
John Ruggiero. I'm the tenant of Elevate Cannabis. So
Louder?
John Ruggiero. So after the last event that we had an issue, we haven't had any other events after that on the premises. We didn't want to make any more issues, so we just stopped with the events.
And it's not to say you shouldn't have them if this is going to help your business. It's just the planning of it. If you are going to have an event, make sure you have valet parking somehow arranged and that, you know, the community, the surrounding neighbors are not disturbed. I mean, you're in an industrial area. It's not like you're going to have a lot of complaints, but just make sure that you plan it properly. That's
Cool.
what I'm asking.
But it's an industrial area, but they're building a huge residential development right across the street. So it's going to be highly residential in short order.
Correct.
So-
I'm just saying now,
I
Has
know,
not
but
happened.
it's part of the bigger picture and the context of this. How does that affect, you know?
No, I'm
the-
sure
The
that-
residents that's gonna be there.
It's industrial buildings.
Anything,
It's a huge development. Yeah.
any event or anything that, I'm sorry. I'm sorry to interrupt you. I thought you were finished. Any event that'd be contemplated by the applicant is always subject to, this applicant or any applicant is always subject to the city building department notice, hiring the police officer to make sure the traffic is there, stuff like that. It's always subject to the city's permit and the codes. But look, your comment is well received. And something goes back to what the chairman said earlier and your counsel said earlier. If that the preemption issue, let's say I'm incorrect on the preemption issue to the boundary, and we do need a variance. If the board feels comfortable in moving forward, I have argued in the alternative. I'm not resting fully upon the preemption issue for the boundary to the playground. I mean, you could make it an approval, a condition approval about the second floor. You could make it a condition of approval regarding to this ancillary first floor, the one-story building, right? You could make it a condition of approval for any events have to follow the city permitting requirements. And if the board finds, if it shares the opinion that the proximity variance is somewhat de minimis, I'm happy to, since I've argued both, if the board felt that it could move this evening, I'm happy to rest upon the application for the variance of the proximity, eliminate the need for the preemption issue as it relates to the boundary.
So here's what I would say and to the board members as well. I think we could come to a decision by next month, and I would prefer for those loose issues to be buttoned up, submitted the information that I requested relative to ownership and licenses. Legal counsel's response to your comments about preemptive, and understanding that even if it's not, we could issue a variance. And so and the second floor, how we're going to word that, I think I'd rather spend some time making sure we word it so that it's legal and it doesn't create a problem for the city or what we ultimately put in that findings of fact.
Sorry, Mr. Chair, can I ask one more question? Has the license been renewed? Because I know the.
Yes, there was.
Okay, thank you.
So yes, is that correct? The license was renewed?
Yes, I'll leave copies here, just so the board can see it. We'll include them also in our supplemental submission.
Okay. And unfortunately, I really don't want to belabor this, but I do need to respond to a fellow board member's comment about this has been going on for quite some time. It has been going on for quite some time, but it's not because of this board. It's because of the myriad of problems that were self-created by the applicant and the representatives of the applicant. We've adjourned this meeting a number of times. It's been improperly noticed. We had an initial representative who subsequently sent a letter saying this whole application is no good. They're violating building code. It's been a mess. And so I don't want the city or this board to be taking responsibility for the delays. It's not us. So with that being said, I'm going to look for an adjournment. Let's just recap the things that we need from the applicant. And if I miss anything, please chime in. So we from the applicant, we just need we have now the license. We just need the LLC of the various business entities that are involved in this operation and how they relate to each other. Go ahead.
I'd say in an org chart?
Well, I mean, whether, yeah, I mean, just to understand where it
Right.
does it have to be an org chart or whatever, something that kind of shows us, you know, the progression of who's what and where and how removed they are from the final product.
Happy to do it. It's 1-2, so happy to show you.
Okay, and then we as a board and a department need to come up with language, and Carl Scully, I would hope that you could help us with that for the second floor and the ancillary building that, you know, again, as noted, if they did do something, they would need to go to building department to get building permits, and that would trigger something. But I do want it to be part of our findings. And the other thing was to just reply to this,
The issue with the.
the issue with the state,
Home rule.
so that we can, again, make a determination as to whether we have to consider the variance or we don't have to. because
Mr.
the
Chairman,
state-
before Mr. Scully replies to me, I thought I had a homework assignment to give you a letter of clarification, then await his reply.
Do that.
All right, okay, that's fine. I just want to make sure our letters don't cross in the mail.
Yeah, okay.
I'll have that out to you by the end of the week.
That's fine.
Thank you, sir.
And I know that there was, and I can't find it now for some reason. There was a letter submitted that resident wanted read into the record, and I think I need to do that. You can read it. It'd be good because I've been talking much too much tonight.
Do you have, isn't it permissible to just reference the date in the submission, or do you have to read the whole thing?
That's up to the chairman. No, we're going to read it in because unfortunately, when letters are written or testimony is given by someone who can't be here, it just doesn't get heard by the public. It goes, and I just think
I know we're saying it was getting late, but it's up,
they
your
just-
discretion.
Now, listen, I want to go home too, so, you know, and it's a little long, so everybody buckle your seatbelt. No, let's see what they are as it goes. It may need clarification. It is a bit more complicated than I'd like it to be. But let's get going.
Okay, so this letter was submitted by Vince Ferrandino, AICP, today, January 20th. Chair Justino and members of the board. My name is Vince Ferrandino, and I am testifying tonight as both a Mount Vernon resident and expert planning witness. First, let me say, as I testified at the September 16, 2025 hearing, that I am not philosophically opposed to the use and dispensing of cannabis in any way as long as it is done in accordance with the law. For the last 2 years, the retail dispensary at 127 South Terrace Avenue has failed to do so with the express knowledge and consent of the city administration. It was at my behest back in November 2024 that the planning board finally referred this application to your board for longstanding area variances. It's taken the applicant much more than 1 year from that date to apply these variances while still operating the business illegally at that location. Second, in my September 16, 2025 testimony, a copy of which is attached to my remarks tonight, see attachment number 1, I raised a number of questions and issues which to date have not been addressed. A number of them pertain to the completeness of the application for the variances and secret documentation. I have discussed them with the city's planning department to no avail. I submit that these omissions are addressed and the application should not go forward. Third, I followed up my September 16, 2025 testimony with an email to the Assistant Planning Commissioner highlighting some of the missing documents, and I requested be put online as part of the package for tonight's hearing. They were not, and he suggested I include them here. Number 1, identification of the members of the applicant LLC, as well as a copy of the LLC agreement. Number 2, a copy of the applicant's cannabis license renewal application from New York State Office of Cannabis Management and any approval of the same, even though the application was submitted before any local land use approvals were obtained. Number 3, a copy of the latest temporary certificate of occupancy and/or temporary certificate of tenancy issued by the building department, as I believe that previous temporary certificates of occupancy tenancy have expired and the building continues to operate without any local permits or approvals in violation of the law. Number 4, any updated plan examiner reports reflecting the applicant's addressing open construction items. The last one on file is June 5th, 2025.
Number 5, amended and dated zoning board application by project engineer Shaheen Badali, eliminating all the errors and inconsistencies in his undated application for area variances discussed and critiqued by me at the September 16, 2025 hearing, including his amending the deficient short form EAF dated 8/1/23 to reflect accurate responses. Number 6, any application and or permits approved for signage on the facade of the 127 South Terrace Avenue building, as well as the high metal fencing in the front yard of the property as without permits, these appear to be in violation of the code. 4th, amended statement of principal points. At my behest, an amended statement of points was prepared by an attorney to correct the project engineer Badali's deficient and embarrassing attempt to do so. However, for many of the same reasons, the current document is self-serving and deficient. Here are some of the reasons why. It fails to mention the illegal occupancy of the building since December 2023, more than 2 years ago without any valid permits. It fails to mention the need for a site plan approval should the requested variances be granted prior to the issuance of the building permit. While it cites recent New York State cannabis law pertaining to 200-foot distance parameter rather than the minimum 500 feet in the city code, it fails to opine whether this is a good policy to protect the interests of the neighborhood, especially with a public park nearby where children play and a church nearby where people worship. Although New York State cites a less stringent distance parameter, I ask if this is discretionary with the municipality. Toward that end, I respectfully ask the board to have its land use counsel, Mr. Scully, opine on this, as it is a key element of this application. Although the applicant's attorney cites a parking count undertaken by a consulting firm, again at my behest, the counts were done on November 7th, 8th, 2025, 2 days in which weather was inclement, heavy winds and rain, which likely skewed the count. See attachment number 2. No photos were taken at that time. On Friday, January 16th, 2026, a clear night between 4:55 p.m. and 5:10 p.m., photos of Elevate parking lot and the street fronting the building were taken by my firm, which portray another picture, cars double parked and the parking at near capacity, including the 3 spaces in front fronting the active auto body shop. See attachment number 3. Piggybacking on that, my contention is that the required parking spaces are 31, reflecting the square footage of the 127 South Terrace Avenue building in which the retail cannabis dispensary is housed, not the 10 spaces the applicant claims it needs to provide. Even the applicant's project engineer cited parking spaces in excess of 10 now sought. The city code is unclear. Section 1004.5 of the New York State Building Code appears to be more appropriate and reasonable for this type of use, not your standard retail. There are other errors and self-serving statements in the attorney's statement of points that mirror the previous effort by Mr. Badali, which I refuted in my September 16, 2025 comments. I will not repeat them here as they are attached to my testimony, but clearly the hardship the applicant claims is indeed self-imposed, as he knowingly made improvements to the building and site with 0 permits and approvals, and now seeks to remedy them post facto. It clearly has not been a seamless operation of the business, as the applicant's attorney erroneously asserts. One final thing for the record, at the last hearing, the owner, Mr. Ruggiero, apparently upset that I was asking substantive questions about his application, angrily and publicly referred to me as a criminal, which I take great exception. On the advice of my attorney, I emailed Mr. Ruggiero, admonishing him to never do that again, putting himself at risk for defamation of character and worse if chooses to do so. I asked Mr. Ruggiero to acknowledge receipt, but he never did. Therefore, I am including that email this evening in my testimony for the record. See attachment number 4. In conclusion, for the reasons mentioned, this applicant should not proceed because the application and the record are incomplete. If it does, pending land use council's research and opinion, the variances should be summarily denied on the merits. The recent New York State pronouncement on the ill-conceived 200-foot distance parameters notwithstanding. On the requested parking variances alone, 31 spaces required, 10 provided. The petition should be denied. Thank you. And then enclosed are 4 attachments, which you do not want me to read?
No.
No, at this point, let's just let them be part of the file. If anybody who is listening and interested, those are going to be in OpenGov.
Right. So the second attachment is what Mr. Ferrandino submitted at the last September 16th meeting. It's the same comments. Those were read into the record, I believe.
Okay.
And then attachment 2 are photos taken on January 16th of the site, showing the car double parked as he described. Attachment number 3 is a AI generated weather data summary. These are not meteorological records, though. This is an AI summary of. It's I looked up the meteorological records. I have a meteorology degree.
Okay.
I looked up the records. They are not the same.
And the applicants betrayal, the applicant's, expert witness was comply with what you found? Weather-wise, it only rained
Correct,
at
yeah.
night?
I'm
Since you
showing,
looked,
yes, so you can only look up, history, meteorological history using the weather stations like at airports and things like that. So the closest one to this site is the LaGuardia Airport Station. On November 7th, there was no precipitation. On November 8th, there was no precipitation.
okay.
And
Now,
that's
that's
part,
at the LaGuardia Airport.
Yeah,
Now,
yeah,
it
yeah.
could be,
No, no, right.
you know,
So
there's
if it was a
some
major,
distance,
if it was a
but that's the
major
closest
event,
one
it
that
would have
has
been
the-
there as well.
yeah, and then, the 4th was, oh, right, I have to change this, the defamation of character. And that's it.
One thing we didn't mention as part of the conditions is that, any missing parking spaces would be subject to fee in lieu of said parking
Yeah,
spaces.
so that's
So
right.
that
That'll
would
be
be
part
part of-
of our findings.
Yeah.
So as everyone's aware, if you cannot supply the amount of parking on site, the on-site parking requirement, there's a fee. If you're granted the variance, there's a fee that's attached to buy space off-site. So it would be a minor fee.
It would be $1,000.
right. I do want to, since we're still on the record, we started the discussion talking about the 9 or the 10 spots. As I'd mentioned earlier, and I don't think I stressed it enough, and that's my mistake. The most recent plan does show a fully compliant 10 parking spot layout. It's just that, and you'll review that. You guys, you have that information and you'll incorporate that for the February meeting. But I believe what we're now dealing with is the variance coming into the loading dock, the loading space. That's it.
So having spoken with the building department about this, it's that one of the spaces on the plans blocks a means of egress from the building, so they discounted it, that's all.
But that's been corrected.
I would need another plan examiner report stating that.
All right. Well, I'll follow up with you tomorrow.
Yeah.
And then we'll have that issue corrected for your meeting in February.
How was that addressed? How has that been corrected?
They're showing now a 4.5 foot wide gap. It's on the plan.
Does that resolve it?
I mean, if you run it through the building department and they do another plan examiner report that then eliminates that parking variance, you would just have the variance for the loading space.
All right, but I don't want to hold up the February meeting over $1,000. So let's keep moving forward and we'll resolve that issue
It's
internally.
probably easier to pay the
Yeah.
$1,000.
Yeah, I agree.
So we were adjourned.
Okay. A motion to adjourn?
Thank you for everyone. Thanks for your time.
Thank you.
So moved.
I make a motion to adjourn the meeting until February 10th.
Okay, Wendy's a motion, Elvira's a second. All in favor of
Aye.
adjourning till the next meeting? Ayes are unanimous. Carl, welcome aboard.
Where? Thank you. My issue.
That is part anyway, then I don't.
During the meeting too.
Because
No, so the next work session is going to now be on the February 10th at 6 o'clock and the public hearing at 6:30 on the 10th as well. Is there a motion to adjourn? Seconded by the chair. All in favor? Aye.